So 19 states have joined together to tell the Supreme Court that they should uphold New York's concealed carry permit restrictions. So let's talk about this. But real quick before we jump into this video, if you think the Supreme Court should strike down carry permit restrictions, go ahead and hit that like button and subscribe. I also want to thank one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, 19 states have joined together and they have filed a brief to the Supreme Court telling the Supreme Court that they should uphold the state of New York's carry permit restrictions in the Supreme Court case that they are hearing, New York State Rifle and Pistol Association v. Corlett/Bruin. This is a case that we are very much anticipating because it's one of the first Second Amendment cases that the Supreme Court will hear in a very long time. This case is a challenge to the state of New York's concealed carry permit requirements. The state of New York requires people to provide proper cause to be issued a permit to carry a firearm concealed. However, they do not treat self-defense as a proper cause or justification for someone to be issued a permit. Essentially, this led to only the elite and well-connected in the area to be granted licenses to carry concealed for self-defense. While these 19 states, led by California, have joined together in filing a brief saying that the Supreme Court should find what the state of New York is doing as valid and not an infringement on Second Amendment rights. The brief starts by the states presenting their claimed interest in the case. They start by saying that this court should affirm the Court of Appeals judgment that petitioners have not stated a claim under the Second Amendment. The court should clarify the governing legal standard and remand for further analysis by the courts below in light of the particular facts and circumstances of this case. In their brief, there are two main arguments that these states make. The first argument is that they argue public carry of firearms has been subject to regulation throughout American history. So they start off by talking about history, early English history, early American history, and then they also go on to current American history. So they're arguing that history is on their side. The second argument that they make is that the Second Amendment gives states flexibility to regulate public carry. So they're arguing that the Second Amendment itself gives states and localities flexibility to regulate the ability of someone to carry a firearm out in public. So first, let's look at the arguments made by these states on the basis of history that supports these types of restrictions. These 19 states argue that a fair-minded and thorough assessment of the history establishes that there is no general right to carry arms into the public square for self-defense, and that states and local governments may regulate arms in the public square. That quote comes directly from the Young v. Hawaii Ninth Circuit open carry en banc decision. The Ninth Circuit in that en banc ruling found and argued and actually determined that under the Second Amendment, you as an individual do not have a right to carry a firearm out in public whatsoever, that the Second Amendment does not protect that right. So that is the general position of these 19 states. And then they start looking at English history. And in looking at English history, they argue that there were English laws that restricted a person's ability to carry arms. For example, laws that restricted carry in public populated areas, but laws that did not place the same type of restrictions on people who live in countryside areas that were not as densely populated. Then after the discussion of English history, they turned to early American history. One of the early American colony examples they point to was that there were colonial mandates that required people to actually carry arms whenever they went to specific places. Like, for example, when they went to church gatherings, there were colonial mandates that said, hey, everybody who has a firearm, who has arms, please carry these when you go to XYZ place. But here, these 19 states tried to dismiss the reality of American history by saying that, yeah, people could carry out in public, but that was dictated by the localities. So they're saying, yes, there's history of people carrying firearms in public, but also they're trying to use these colonies by saying there were colonial mandates, and that points to the fact that these colonies had the right to dictate whether people could carry out in public or not. So again, you can see how they're trying to skew this history in their favor. Now there in that section, and later on in the brief, you can also see that they make arguments about how these laws that said, yes, you could carry firearms out in public were often tied to fear of slavery or Native American attacks. So they're using this tactic by saying, yes, there were these laws on the books, but they were racist and that these people were just afraid of, I guess, being attacked by these individuals, or essentially having these other policies which were clearly wrong, backfiring against them, and they just wanted their people to carry firearms, but these were all racist laws. Again, it's a really embarrassing tactic, and something you don't see them talk at all in their brief about is the real historical context, which is a discussion about how most often all these gun control laws that were put in place, these early gun control laws that they tried to lean on later in their brief about the kind of modern American history, a lot of these gun control laws were put in place because they were racist policies. They wanted to strip minority groups of their rights to have access to firearms. Now, another really interesting thing that I found in this history section is that they even mentioned the famous carry restrictions in mining towns like Tombstone. Now, just a quick tangent, Tombstone is one of my favorite movies of all time. Like, I can quote that movie from start to finish. But really, when you look at what happened in that town, yes, what Wyatt Earp and what the Earps were doing was clearly a violation of Second Amendment rights. They were restricting an individual's ability to carry a firearm out in public. And here they're trying to say, like, and I don't really know what they're trying to do here. I don't know if they're trying to point to, like, all these people on the right love, the Wild West. They love movies like Tombstone. But look, even here, your idols were restricting the right to carry. But even there, that was not something legitimate. That was a violation of constitutional rights. And pointing to that one example really doesn't support what they're trying to argue here in this brief. Because when you look at the reaction to those individuals in Tombstone, the residents and those people around, the reaction was very much against what the Earps were doing, because traditionally in America at this time, people were carrying firearms open. They were carrying them out in public. There were not restrictions like this. This restriction in Tombstone was an outlier. Then after this discussion of Tombstone, they move on to more modern history, and they argue that since 29 states require some form of license to carry concealed, that is evidence that this type of restriction is permissible under the Constitution. However, like we all know, just because a law is in place doesn't mean it is constitutional. It just means that likely 29 states are potentially enforcing unconstitutional laws that need to be overturned. Now, that's pretty much the whole discussion of history that takes up quite a bit of the brief of these 19 states. And then they next move to the argument that the Second Amendment gives states flexibility to put in place these types of restrictions. Now, from the very outset, when you hear that the Second Amendment, and you're hearing that states are arguing that the Second Amendment gives them flexibility to put in place these types of restrictions, it points to the fact that they are just completely ignoring the text of the Second Amendment. Because I don't know about you, but the last time I read the Second Amendment, it says shall not be infringed. And shall not be infringed doesn't really lead to the conclusion that this amendment is giving people flexibility to put in place anything that they want. It sounds pretty resolute in what it's saying, shall not be infringed. In this section, they argue that a test based solely on text, history, and tradition would also prove unworkable in many contexts. So they're talking about the type of analysis that should be applied in these cases. And from the outset, they're saying, we don't want to use text, history, and tradition because they know really if they use text, history, and tradition, they would lose under any critical analysis. But instead, what they want to use is tiered-based scrutiny. They argue that the history that they presented early in the brief and the restrictions that they pointed to means that public carry for self-defense is not at the core of the Second Amendment. They state that when individuals move beyond the curtilage of their homes, and particularly when they move about in populated areas, their interest in carrying a firearm for self-defense is much more likely to come into conflict with the public interest in order and in safety. So essentially, what this argument amounts to, what these 19 states are saying, is that the second you walk outside of your door, when you pass that curtilage of your home, all of a sudden your Second Amendment rights go from here all the way down to here. So we will be waiting to see how some of these issues are addressed by the Supreme Court. And the Supreme Court will be hearing oral arguments in this case on November 3rd, and they might address some of these things that were presented in this brief. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It signals to YouTube that you see value in these videos, in this type of Second Amendment news, and then it pushes it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You are definitely impacting the channel. You're helping the channel to grow, and we are approaching 200,000 subscribers, which was one of my goals for the end of the year. So hopefully we reach that. So thank you to everybody who subscribed. And if you're a new subscriber, make sure you comment down below and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is Built Bar Arms Scholars, and the station we maintain Bar Arms Scholars.